now to James Westgate, who is a partner with the PE practice within Bowmans. Bowmans, of course, is a SAVCA member and one of the largest law firms in South Africa. And with 7 offices in over 5 countries on the continent, is very well placed to take us through today's topic of discussion, which is navigating distressed portfolios. So enjoy the webinar. I'm handing over to you, James.
Thanks, Mel, and good afternoon, everybody. Thanks for joining the Bowmans webinar today. I think there were over 180 registrations. That's a great response, and I'm sure it's got nothing to do with trying to get your CPD points. As Mel said, my name is James, and I'm a partner in the Bowmans private equity team. I'm joined today by my panel fellow partners, Josh Janks. Josh sits in our Cape Town office and is a partner in our private equity team. Also joining us is Timothy McDougall. Tim is also a partner in our private equity team based in sitting in Joburg. Next person who we'll hear from is Ulrike Naumann. Ulrike is the head of our banking and finance team. She kind of flits between Joburg and Cape Town depending on the weather, I think. And then Juliette de Hutton, who specializes in business rescue and insolvency. Juliette is also in Cape Town and Joburg as clients' need determine. We're going to be looking to talk for the next 45 minutes and to leave some time at the end to answer any questions that you guys might have. I'll be moderating the session and trying to bring all the different streams together and try to give you an overall picture of the issues that we're facing and hopefully some solutions to the pertinent problems that I'm sure all of us are seeing in our portfolio companies. To start, maybe as befits a call with 5 lawyers on it, it's maybe get the legal disclaimer out the way, that the following discussions cannot be construed as formal legal advice, and we strongly suggest that you talk to your lawyers, preferably Bowmans, to come up with a tailor-made solution to any specific situation that you might be facing. With that said, we are facing unprecedented times at the moment, with every sector facing massive disruption and risk caused by the coronavirus and the resultant lockdowns and mitigation measures that have been taken. We assume that all of you are doing what you can do in your portfolio companies in terms of managing downstream risk, making sure that your working capital cycles are effectively managed and taking advantage of any of the other incentives or tax breaks that might be coming our way out of the relief packages that have been recently announced. But what we want to examine today specifically is what you as a private equity executive sitting on the board of a portfolio company that is facing a cash crunch and possible liquidity and solvency issues in the near future can do to mitigate your risk and navigate your way through the various options that might be available. Broadly, we're going to look at focusing on 3 main areas. Firstly, look into your shareholders. Secondly, look into third-party credit providers such as banks. Secondly to them. Thirdly, to seeing what other statutory remedies you might have to provide some protection and breathing space to allow recovery or to run an orderly withdrawal process. The best place to start might be just to look at what your specific duties are as a director on your portfolio company board. The specter of personal liability, I find, always tends to focus the mind somewhat. Juliette, maybe you can take us through the position here. I think just unmute them.
I see I've been muted by the host. Have you unmuted me now? Yeah. Okay, great. Sorry about that. So I'm going to focus obviously on the particular the duties and potential liability that comes into play under a scenario of financial distress rather than directors' duties in general. Where I'll start, because it's something that always concerns people, and at the moment we're getting a lot of queries, is the concept of reckless trading. So the first point to note is that reckless trading features in both the Old Companies Act and the New Companies Act. Why is that relevant? Well, it is because if a company ends up in liquidation, it is still the Old Companies Act that governs the position. Of course, if you don't end up in liquidation, it's going to be the New Companies Act we look at. So if we start with the Old Companies Act, And let me preface this by saying under both the Old and New Companies Act, it's not just civil liability you can attract as a director in reckless trading circumstances, but also criminal liability. The Old Companies Act basically says that liability under Section 424 arises in the event that the business of the company is being carried on recklessly or with the intent to defraud creditors or for any other fraudulent purpose. So let's leave aside the cases of fraud now, which hopefully will not be relevant. Recklessness is the issue that we need to look at. And what is recklessness? So first of all, it's important to note that recklessly doesn't connote just normal negligence. It's really something quite specific. You must have been grossly negligent or displayed a reckless disregard for the consequences of your actions. So the section is not aimed at penalizing ordinary negligence or even possibly poor judgment. It's really aimed at penalizing, subjecting third parties and creditors to risk when it's grossly unreasonable. So effectively when you are gambling with your creditors' money. The test for recklessness has two elements, a subjective element and an objective element. So objectively, we look at the director's actions and we measure those against the standard of conduct of a notional, reasonable business person. The subjective element is that we postulate that the notional business person as belonging to the same group or class as that particular director, moving in the same circles, having the same knowledge as that director. And the courts, in short, have stated that if a company continues to carry on business and to incur debts when, in the opinion of this notional reasonable business person, there would be no real prospect of creditors being paid when their debts fall due, you are trading recklessly. Now, where the objective part of the test becomes critical is what this means is that if you take into account that objective element, if even as a director, you honestly believe you're going to be able to pay your debt, your creditors, you're incurring a new debt, you think you're going to be able to pay the creditors, but if a reasonable person standing in your shoes would not have held that belief, you are still going to be potentially liable for reckless trading. I also just want to emphasize that reckless trading liability in the old Act is not limited to directors. It actually refers to any person who's knowingly party to carrying on the business in the reckless manner. So, for example, a shareholder could also be held liable for reckless trading. And I personally have issued at least one summons against a shareholder. It was the major shareholder. It had representatives on the board of the company. And effectively, this shareholder was calling the shots and dictating how the company behaved. And they were ultimately sued for reckless trading. I also want to emphasize that reckless trading doesn't require active trading. So, for example, what you could be criticized for is an asset disposal process and the way you then dealt with those proceeds. Another example would be falsifying financial statements, inflating income. Those, although not trading as such, can be acts which result in you being held liable for reckless trading. So that's the old Act. If we look at the new Act, basically that's got Section 22, which says that a company must not carry on its business recklessly with gross negligence or intent to defraud. So there they actually use the phrase grossly negligent along with recklessness. And in terms of Section 77, that you as a director can be liable for any loss the company suffers if you acquiesce in the carrying on of business in a way that breaches Section 22. And then in Section 218, you can be liable to any person who suffers a loss as a result of you breaching that reckless trading standard. Reckless trading is not defined in the new Act, so all the case law that's developed around the old Act as to what reckless trading means likewise applies. So if you're needing to look at whether your company is potentially trading recklessly and you can be held liable, there's obviously a lot of things you need to take into account. But the critical one really, the main issue is cash flow. You've got to look at your liquidity, and particularly when you're looking at incurring any new debt, whether there is a reasonable prospect of you being able to repay that debt in due course. Then just to mention briefly, other elements of director's liability, there's your standard Section 77 director's liability, where you can be held liable to the company for breaches of your fiduciary duties, etc. And as we mentioned earlier, any contravention of the Companies Act can result in you being held personally liable to anyone who suffers a loss by virtue of that contravention. I also think it's worth briefly mentioning the prospect of being declared a delinquent director or under probation. That's in section 162 of the Companies Act. And an application to have you declared delinquent could be made by a variety of people. It could be the company itself, it could be a fellow director, it could be a shareholder. Curiously, it can't be a creditor. And what it requires really is that you behaved in a way that amounted to gross negligence, willful misconduct, breach of trust, that sort of thing. The consequences are that you can be prohibited from becoming a director potentially for the rest of your life, or it could be for a more defined period. And the court could also order that you as a director pay compensation to anyone who has been adversely affected by that conduct. The last thing I want to look at quickly is section 1297 of the Companies Act. So that is a section that sits in the business rescue chapter. The first thing you need to understand is how the Companies Act defines financially distressed, and there are essentially two tests. The first is that it appears to be reasonably unlikely that the company will be able to pay its debts as they become due and payable within the immediately ensuing 6 months. So it's looking ahead 6 months and assessing your liquidity. Are you going to be able to pay debts as they fall due? The second test is that it appears to be reasonably likely that the company will become insolvent within the immediately ensuing 6 months. So that's a factual solvency, assets, liabilities test. And those are the two things you look at to determine whether or not you are financially distressed. Now, what section 1297 says, that if a board has reasonable grounds to believe that a company is financially distressed, it's got two choices. The first is that it can put the company into business rescue. The second is, and this is where it gets tricky, is you can deliver a notice to all affected persons of the company. Now that is all your creditors, your shareholders, your employees, all trade unions. And that notice must inform them of the fact that you've decided that the company is financially distressed, but nevertheless have decided not to put it into business rescue, and you need to explain why you've made that decision. Now, the consequences of not going for one of those two options is that, first of all, there's a risk for you as a director being convicted of a criminal offense if the court ultimately decides that your behavior was calculated to defraud creditors. And again, you can be liable for the loss anyone suffers as a result of you contravening that provision. Now, in practice, no one wants to send a section 1297 notice. You can imagine the consequences of sending a notice like that to all of your creditors. It will be hugely damaging to the company's reputation and its goodwill. It could even amount to a default under your various facilities, trigger cross defaults. It will then hinder your ability to deal with your suppliers, your creditors, your bank. And you need to take very careful steps to be put in a position where you never have to send that notice. There are steps you can take to prevent it, but you can understand that what the legislature was trying to do here is say, if you are financially distressed, you need to do something about it. You need to put yourself in business rescue, or if you don't, there has to be a very good reason for it. And some of those reasons that you would take into account is, for example, if you're in the middle of negotiations with a new investor, a new financier, and you genuinely believe that you're going to get new funding that's going to be able to see you through the time, and you're not going to be in a position where you can't pay your debts. It might be that you anticipate reaching agreements with creditors to extend the period over which you repay debts. But it's something that you need to take careful advice on if you ever find yourself in a situation where it looks like you're falling under that definition of financially distressed. Thanks. That's James.
Thanks, Juliette. There were rumors that the rector's trading provisions were suspended for the duration of the lockdown. Can you give us a bit more info on that?
Yes, SAVCA released a practice note which basically said that it was going to suspend the need to issue notices under Section 22 of the Companies Act for the duration of the period we're under the disaster scenario. But what that means is all they're doing is suspending the fact that they're going to send out notices calling on people to show why they are not financially distressed and shouldn't be put into business rescue. It doesn't mean you're no longer liable for reckless trading. So that notice that SAVCA put out has had a limited effect, and I think the press reports of it have been a little bit misleading. There's absolutely no way you can contend that you're not liable for reckless trading despite what's going on at the moment.
Thanks. So with that done, let's maybe look at our first, or what we think might be the most logical next step to take, and that's approaching your shareholders to look to raise new money. We're not necessarily suggesting that this will always be first, or that this is a linear progression. You might well be looking at all the options you can at the same time around here. But for the purposes of today, let's presume that the first step is to approach your shareholders. Tim, where do you think we should start?
Thanks, James. Yeah, now that Juliette scared us all witless, let's talk on a slightly softer topic. As we mentioned earlier, we've assumed here that we've got a distressed company. It's going to need funding in one form or another, or a combination of funding options in the not too distant future. So it's very important at this point that all the relevant role players, be they shareholders or directors, understand the process that is going to be followed in sourcing that funding for the company. And as I said, your typical place to start is the shareholders agreement and/or the MOI, your constitutional documents, which would normally contain a prescriptive process which needs to be followed in terms of raising funding from your shareholders and also from external sources. That being said, that process is one thing, but there is nothing stopping the relevant parties from reaching an alternative agreement when it comes to funding arrangements. However, it's probably still very important that you do understand the more prescriptive process within the constitutional documents, keeping in mind that if you fail to come up with an alternative arrangement, then that's going to be your fallback position. And your strengths and weaknesses for you as a shareholder or a director under that fallback position will determine what leverage you can bring to bear in an alternative arrangement or in a negotiation around an alternative arrangement. Obviously, to the extent that your constitutional documents are silent, then the prerogative sits with the board in determining how to go about the fundraising process. But for the purposes of this discussion, we're going to assume that you do have funding provisions within your constitutional documents. And what I'd like to do is walk you through what I think, at least, that you should be looking at when you review those provisions in the current circumstances. So I think the first place to start is the funding waterfall. What you would expect to see is some kind of waterfall which sets out where the board should start in terms of looking for funding, and you would expect this to first port of call to be internal resources of the company. In the current circumstances and in the example that we've posited here, let's assume that that's obviously going to be a non-starter. Secondly, would be to look to external financing sources, which would typically be the banks or MES debt or some form of other alternative external funding. And then as a last resort, look to the shareholders to put in their funding. Ulrike is going to talk more around the bank debt and the bank financing, but keep in mind that in this example that we put forward here, it's more than likely that any bank is going to want shareholders to come in alongside them. So it's still important, even when considering bank finance, to consider where your obligations and rights lie from a shareholder funding perspective. Okay, so we've got the waterfall. We know where we stand in the waterfall. The next thing to think about is who makes the decision to call on the shareholders to provide their funding. Typically, this would be a board decision, but it is, and in this respect, I would suggest that everyone carefully reviews their board appointment rights and make sure that you are fully represented on the board to the full extent of the rights granted to you in your constitutional documents. It's also worth taking a look at your reserve matters, if any. We wouldn't typically expect to see a reserve matter which fully allows a minority shareholder to block a funding provision. But that being said, there may be relevant reserve matters, for example, a reserve matter which doesn't allow dilution below a specific percentage without some kind of minority consent. And these things may constrain the form or extent of shareholder funding that can be provided. The next thing, and probably most important, is do the constitutional documents prescribe the form that shareholder funding should come in, should be provided? And this could be any number of things, but most typically it would be one of either shareholder loans or an issue of further shares. Obviously, the two have very different outcomes and impacts on shareholders, and whether it's one or the other will definitely impact a decision that a shareholder makes in terms of whether it's going to fund, how much it's going to fund, whether it's going to take up excess, etc. And they have very different considerations as well. So from a shareholder loan perspective, there are probably three things you want to look at. Firstly, obviously, what are the terms of that loan? Your constitutional documents are typically not prescriptive as to what those terms would be. It's normally up to the board to put forward the terms that they believe to be reasonable to both parties. The reason we don't see prescriptive measures in that respect is because when shareholders are negotiating a shareholders agreement, they don't know what the credit rating or credibility of that company is going to be at the time that they are called upon to provide funding. So it's unlikely that you're going to have exact terms agreed up front. A second point just to check for is just make doubly sure that your loans would be repaid in preference to or in priority to the issue of or the declaration and payment of any dividends going forward, especially if you are going to be providing excess, or if you're going to be or if there are going to be shareholders who don't follow their or provide their pro rata portion. You don't want them obviously receiving dividends while your loan sits unpaid. And then lastly, on loans, just make sure or check whether there are any provisions which allow you to capitalize that loan at a later point, either all or a portion thereof. From a rights issue perspective or an issue of shares perspective, your biggest issue obviously is the price at which those shares are going to be issued. So pay careful attention to any market value type provisions and determination provisions that are prescribed in the constitutional documents, particularly whether you think they are going to be applicable in the current situation. Things that, for example, look at historical data may not present a fair position of the value of the company at the moment. The last thing I just wanted to touch on then was just timelines. Make sure you understand the process that's going to be followed and the timelines that are involved in that process. What you would normally see is the board having the ability to call on the shareholders to provide funding, and then a prescribed period within which the shareholders need to respond on whether or not they're going to fund, how much they're going to fund, whether they want to put in excess, etc. The key issue being that time period. If you are a potential shareholder who's going to be funding, keep that time period in mind, because if you identify at an early stage that is a particularly tight time period for you for whatever reason, if it's, for example, going to take you longer to raise money from investors or LPs, you can start that process early and be proactive. So I think that's a very high level look at what I think the sort of key issues you need to consider when you review your funding provisions in the documents. Josh is going to speak a little bit later about the implications of funding, particularly around dilution and whether that triggers any change in your dynamic as shareholders, may trigger legislative consequences, etc. But I'll let Josh talk on that later, and then hand back to you now, James.
Thanks, Tim. Have you learned any lessons, or have you seen any obvious weaknesses in some of the shareholders' agreements that you have looked at over the last few weeks with a view to the funding process?
I think it's more even more general than what's come out of the recent crisis. But if your process that's set out in your documents is overly cumbersome and time-consuming, that works in a situation where you are looking to raise funds for potentially a specific CapEx spend or project or an acquisition where you've got time to raise that money. But where it's needed in more of an emergency funding situation, there needs to be more flexibility. And obviously that's directly applicable at the moment for a lot of companies. So what we typically try to include over and above the standard process is an emergency funding process whereby in a limited set of narrow instances, the company can call on funding from shareholders on an expedited basis, particularly potentially in a different form, which is easier to get funding in quickly. And those narrow examples would be limited to things like in order to cure insolvency related issues, maybe an event of insolvent event, a breach of covenants or other defaults with your finances, or even a breach of applicable law. So it's important that there is some degree of flexibility in the process.
Thanks, Tim. Let's move to third-party finance now. Ulrike, can you maybe take us through the initial engagements with lenders and what their main focus might be in these kind of situations?
Thanks, James. Absolutely. So as was mentioned earlier on, when a company finds itself in financial difficulties, it is important to engage with all stakeholders, shareholders, employees, management, and importantly also your debt providers. I think early, sensible and honest engagement by the borrower is essential to build or restore trust with the lenders for the restructuring process. The process can often take a lot longer than anticipated, and building that relationship of trust and that you're moving in the same direction early on is really critical. As part of the process of engagement with the lenders, the borrower should be prepared to share information with the lenders quite early on, and that information will form the basis on which lenders will base their response. Now, some of the initial information that lenders will ask for include a 13-week cash flow analysis and potentially also a business recovery plan. Now, I understand that in the current circumstance, it may be difficult to generate this information. I think no one knows what the economy will look like post the lockdown and how the economy will be opened up slowly. But it's important for the company and the lenders to work together to put together the best estimate of a base case model on which any kind of debt restructuring will be based. The COVID-19 pandemic and the consequent lockdown have put tremendous pressure on businesses, resulting in a lack of liquidity. Borrowers will find that they either have no cash to pay interest or capital amounts that have become due or are becoming due, or in an effort to preserve the little cash that they may have, will want to defer these payments until cash flows have stabilized. So when we look at debt restructures, I think one can probably categorize them into three categories. The first would be what I kind of term quick fixes or immediate responses, addressing an immediate liquidity need or an immediate event of default that has occurred. The second is a more medium-term solution where beyond the quick fix, there needs to be some kind of adjustment to the capital structure to ensure that the capital structure remains sustainable. I think the third is more of a drastic kind of debt restructure where clearly the current level of debt, irrespective of whether it's senior or junior or mezz, etc., is not sustainable, and where another solution is required, either as a result of, either through shareholder support, or if shareholders are not willing to support the business, ultimately through lenders considering a debt to equity conversion or enforcement of their securities. So I'll take you through some of the nuances of each of those three categories in our discussion today. So after the initial engagement with the debt providers, borrowers will find that immediate and short-term responses to their financial difficulties, in particular the kind of financial difficulties that would have arisen as a result of the lockdown, may include providing liquidity facilities, which are specifically tailored to absorb some of the impact of the lockdown and the slow reopening of the economy, formally deferring interest and capital payments, perhaps adjusting financial covenants, in particular those that will need to be tested in the next couple of months, without any generation of earnings for a period of 5 weeks. The EBITDA numbers are likely to have suffered, and potentially waiving any other kind of events of default that may have arisen as a result of the lockdown. As I said, these are quick and immediate responses that will assist the borrower to continue trading. Juliette mentioned reckless trading earlier. So these measures will assist the borrower to continue trading, and will give some comfort to the board around the manner in which they're trading, and will avoid the occurrence of an event of default under the debt facilities, which, if it had occurred, may well have knock-on effects on other contractual arrangements that the company may have, or the accounting treatment of the debt. Where the financial difficulties of the companies are not primarily related to the current pandemic, or where the pandemic is likely to have a long-term or medium-term impact on the company, I think lenders will want to seek a more sustainable solution. So the quick fixes that I mentioned just now might still be implemented, but that's not where things will end. So instead of kicking the can down the road through short-term solutions, the company will need to put forward a restructure plan that reflects a more sustainable capital structure. Depending on the depth of the financial difficulties, lenders may be prepared to take additional risk, but will need to be compensated for such additional risk. So when we look at the kind of phase 2, more substantial changes to the capital structure, the things that come to mind are, for instance, converting a portion of the senior debt to a higher paying but structurally subordinated mezzanine type instrument, where perhaps the obligation to pay interest or capital payments may be subject to compliance with certain financial covenants, or where the mezzanine instrument is excluded from the calculation of financial covenants applicable to the senior debt. So that would be one way of restructuring the debt by taking some of the senior debt and converting it into a mezz portion. Similarly, you could convert a portion of the senior debt into a PIK instrument where interest is capitalized and only paid at a later stage. Or perhaps even more drastically, you could even convert a portion of the senior debt into a convertible loan, or perhaps a preference share. Naturally, all of these solutions will eat into the return that is earned by the shareholders on their investment, but will compensate the lenders for the increased risk that they are taking. The willingness on the part of the lenders to enter into any of these arrangements will most likely depend on the financial position of the company before the lockdown. So if, for instance, a company was already in financial difficulties before the lockdown, lenders may not view these as appropriate means to stabilize the company. When looking at some of the structuring solutions and that are available to the company and the lenders to address potential capital restructures and debt restructures, some of the information that is very relevant to the lenders is the question of stretched payables. What are the credit terms with your other trade creditors, for instance? Has the company entered into off-market business terms with any counterpart? Is there a lack of alternative financing sources? What is the sustainability of the financing structure? And are there any audit opinion concerns that may well not be addressed through these measures that we've just spoken about? So if they're above, if these debt restructuring measures are not sufficient, then lenders will place increasing pressure on the shareholders of the company to support the business and provide some form of liquidity.
Thanks, Uli. So assuming then that the shareholders have committed additional equity, what knock-on issues or unintended ramifications would one need to keep an eye on, Josh?
Thanks, James. So you obviously, the outcomes are either that you put some more money in as a shareholder and your shareholding stays the same or increases depending on what others are doing, or you don't follow your proportionate allocation and you dilute. And I think what's important to understand up front is you may not know which way you're going at the start of any process, and so you need to explore the potential consequences both of the funding and non-funding route. So let's start and look at it as if you are a shareholder that is putting in funding and your shareholding percentage is likely to increase. So I think the first thing to think about is the strategic thresholds within the company and whether you might cross any of those. So for example, if you are going across a threshold that gives you control over the company from a competition law perspective, you might need to then notify and get a merger approval. I think it's important to understand as well is that threshold isn't necessarily at 50%. So a shareholder who is a minority might put in capital and increase their stake, still be below 50%, but need to notify and get a competition approval. The other thing, I suppose, in the funding route is to be aware of is the mandatory offer thresholds, to the extent that your portfolio company is a company that's regulated by the takeover regulations. And there, if you increase your debt through your shareholding threshold from below 35% to above that threshold, you may be required to make a mandatory offer to all of the other shareholders. Obviously, in a distressed company, that might be a very unfortunate thing to have to do. And so I think it's important to monitor these things as you're in the process. And obviously, there are ways of waiving those consequences or having them avoided. So you need to think that through quite carefully before putting that money in. I think from a private equity shareholder perspective, obviously one of the important things to think about is can you actually advance the funding? Do you as a fund obviously have dry powder, but also what are the mandate restrictions in the fund's own constitutional documents? Are you allowed to make follow-on investments or get greater exposure to a particular asset? And I think upfront you should be considering those things, because if you have difficulty in doing those, you might need to start engaging with the fund's investors upfront. You might need to get amendments or waivers of the fund's documents, or if the fund investors are not all willing to participate in it, or the mandate doesn't allow it, you might need to create parallel or co-investment vehicles to invest into the portfolio company. I think if we look at the other side, that you don't put in your pro rata funding or any funding at all and are then diluted, I think we'd need to think what then happens. And so firstly, I would look at the thresholds in the company and see which of those you had previously relied on for some protection. So for example, it's quite common to set a right to appoint a director or to nominate a director at certain shareholding levels. And I think if you drop below those levels, you might then lose the ability to appoint a director. That sometimes has an automatic consequence that immediately once you've crossed that threshold, your director is removed. So these are things to think about, as well as obviously falling below strategic blocking voting threshold. So 25%, for example, which would prevent you from vetoing any special resolutions. I think you also need to look at your drag and tag along percentages and meeting quorum requirements to see how all those might play out with your new shareholding threshold. I think what's very important to think about is the company's BE status, if it has a BE shareholder, and if that shareholder is likely to be diluted. That will be particularly relevant to companies that have licenses that rely on a particular shareholding, or where their business model depends on a particular BE rating, which is informed by that shareholding, and the ability to trade out of this distress to recover is obviously going to then be impacted by a lower BE shareholding and BE scoring. So it's important that these things are factored in up front, and potentially in looking at whether you are putting in funding, you might need to be considering whether some of that funding goes to the BE shareholding and in some way to support their continued participation. I think the other thing to touch on is the management incentives. I think in order for any rescue to be effective, or any recovery of a company to be effective, you'll need management to be aligned. And I think obviously we're in a difficult time at the moment where cash flow is incredibly tight, and so your ability to incentivize management with cash incentives is probably very limited. So I think what we are seeing is a big move towards equity incentives, restricted equity instruments, limited kind of performance criteria, but rather time-based criteria, and those are quite useful at the moment to keep management involved and keep them aligned with the shareholders' interests. Obviously, what's important to also think about is, and this is what Ulrike made earlier, was, is the distress COVID related, or is the company in distress because it was not performing properly in any event? And I think if that is the case, you might then really need to bring in additional management expertise in order to try and assist in trading out of this difficulty. And what is probably useful is to consider whether you should bring in management skills that have experience in turnarounds and distressed companies. I think those for me are the kind of the high level things to think about at this stage.
Thanks, Josh. On the assumption now that the shareholders will not or cannot commit more money, and the original steps taken by lenders are not sufficient, and that we're looking at a possible default on bank debt, where does that leave us, Ulrike? What are the restructuring options available?
Yeah, so I think if shareholders are either they cannot because they themselves don't have the necessary liquidity, or they're not prepared to provide further liquidity to the company and support the company, then lenders will, together with the company, need to consider more drastic options to protect their interests. Now, I spoke about the quick fix kind of plaster on the small wound option earlier on. Then I spoke about the more medium-term capital restructure, which would still mean that the debt is in the business, and there has been no proper deleveraging of the business. What we're looking at now is a scenario where lenders will, as I said, consider more drastic options to protect their interests. So in these circumstances, I would strongly recommend both to the company and to the lenders that they enter into some form of standstill arrangement, where lenders effectively agree to either waive certain defaults or not to enforce their rights for a certain period of time. This will give the company the necessary breathing space to continue operating its business, whilst at the same time negotiating a restructure proposal with its creditors without the fear of trading recklessly or lenders accelerating their loans unexpectedly. During the standstill period, the lenders in the company will share information and try and find a consensual solution. Consensual solutions are most often preferable to any other approach due to the potential value destruction and reputational damage that may arise from a non-consensual approach. Lenders will often appoint a financial advisor and may also require the borrower to appoint a restructuring officer to guide the company and the board through the restructuring process. I think the need for an external advisor or a restructuring officer to be appointed to the company that is in distress will depend somewhat on the quality of the management team and their ability to navigate the company through a potential restructuring process. Again, I think the appointment of what we often call a chief restructuring officer, a CRO, is more likely to be necessary where the financial distress and the financial problems that the company is experiencing are not solely due to the COVID pandemic, but perhaps due to more material market shifts or other issues in the business. So what are these more drastic forms of debt restructurings that I spoke about earlier on? These more drastic forms often entail enforcement of security or lenders converting debt to equity, either ordinary shares or some form of preference share, thereby either diluting or even completely exiting the existing shareholders. We often speak about ranking and preference and consider that the lenders, if they are secured lenders, that they are in a very strong position. I think the reality is somewhat different. Firstly, because the company and the lenders will need to consider the position of the trade creditors of the company. So trade creditors in most instances are not secured creditors. So technically and from a legal perspective and on insolvency, they would rank behind the secured creditors. However, the reality is that most businesses need their trade creditors to continue delivering the goods and services that they do in order for the business to function. So in reality, what we often see is that despite the fact that you've got these senior secured creditors, that any repayment of the senior secured debt will, from a cash flow perspective, effectively rank behind the payments that are made to trade creditors that need to continue supplying the business. Trade creditors, when delivering services or products to distressed companies, often require these companies to pay cash on delivery, often, and that obviously creates additional liquidity problems for the business. So as I mentioned, when we look at the strength of the lender's position, I think that strength is sometimes undermined by the rights and the power that the trade creditors have over the company and indirectly over the lenders. Secondly, lenders will consider the extent of their security and the ease of enforcement of such a security. So you'll have a wide range of companies that lenders have financed. Some companies have really valuable assets, a lot of machinery that the lenders might have security over and might be able to sell for a reasonable value, and the proceeds of enforcement of their security can repay the debt. In many other cases, the value of the security, if you sell these assets individually, is not that great, and hence enforcement of the security really doesn't make sense. I think thirdly, the willingness of lenders to enforce the security also depends on the type of security that they have. And And what I'm talking about here really is that to enforce security over individual assets, bank accounts, trade debtors, etc., is incredibly value dilutive, and lenders will be far more inclined to enforce their security if they have security over the shares and shareholder claims in the business, because then they can take over the business as a whole without disrupting the business. So from a company's perspective, I think it's important to bear these things in mind. I think also from a shareholder perspective, it's important to understand the strength of the lender's security, because I do think it plays a significant role in understanding what the options are of the creditors in these distress scenarios. The conversion of debt to equity is, or has become in South Africa, a real option for lenders and should not be underestimated. I think 5 or 10 years ago, South African lenders may have been loath to enforce their rights under security documents, but given the pressure that has been placed on businesses and banks over the last couple of years, we've increasingly seen lenders being willing to enforce their security and become shareholders, direct shareholders in the businesses that they've funded. I think Edcon, for instance, is a good example of that. Other factors that need to be taken into account when thinking either about consensual debt to equity conversion or lenders becoming shareholders through enforcement of their security is the valuation of the business, in particular whether there's any remaining equity value left in the business after taking into account amounts owing to third-party creditors, the impact of any change in shareholding or change of control issues in the business on important contracts that the company might be party to, the impact that this may have on any BEE shareholding and the importance of the BEE shareholding to the business, and lastly, and quite importantly also, the impact this may have on management. I think, as many of you are aware, I think in the context of private equity transactions, in many cases, lenders place particular reliance on both sponsors. They back sponsors, but they also back management teams, and hence making sure that in a restructured company, that management team continues to be sufficiently incentivized, I think is a very relevant consideration in the context of debt restructurings. So I think in summary, debt restructurings are complex and can range from short-term deferrals and waivers and amend and extend, or introduction of new debt instruments, to full-blown debt to equity conversions. However, there are also instances where none of these processes, no matter how hard the different stakeholders try and save the business, are successful, and where more drastic measures will become relevant, either as a matter of law or as a means to achieve a certain goal.
Thanks, Ulrike. Maybe across to Juliette now. Juliette, assuming that the worst has come to the worst and that the measures discussed earlier by our panel are unlikely to work or have not worked, what other options are left open to directors of a distressed portfolio company?
Okay, so in South African law, there are really 3 statutory processes that you could now fall back on, and those are obviously liquidation, business rescue, and then Section 155 compromises. Just a couple of preliminary comments that I want to make. First of all, if you get to this point in time, there are a couple of things you have to be very careful about. One of those is how you're dealing with your creditors. So first of all, obviously, you have to be careful about picking and choosing which creditors you pay. If you do that and you prefer some creditors over others, there's a good chance that if the company does end up in liquidation, which obviously is not where you're hoping to end up, but if you do, those payments could be set aside by a liquidator in due course. So you need to be very careful how you're managing creditors who you're choosing to pay. That said, there's one type of payment liquidators very seldom will set aside, and that is when employees are paid. So if there's anyone you're going to pay, if you have some money, the safest bet is to use that on employees. A further thing to be very careful about is not paying insurers, particularly when you're in financial distress. That's one payment you really don't want to fall behind on, because you might need to rely on that insurance in some shape or form. And a classic example would be if you have directors and officers policies which are going to protect them in the case of possibly down the line a reckless trading action, for instance. A couple of other practical considerations. When you find yourself in this position of distress and you've kind of run out of options, it's very, very important for the board to be meeting very, very regularly and assessing their position. They need to be thinking very carefully. They need to be minuting very carefully what's going on, what decisions they make, why those decisions are made, so that you've got that paper trail in case anyone turns around and points fingers at them in due course. So it's a continuous assessment the board needs to make of the position it's in. It's not good enough to meet every 3 months to talk about it. You need to be meeting regularly, and we see examples of businesses in a cash flow crunch literally having liquidity meetings every day, and sometimes even having advisors present at those meetings. Obviously, if there are any significant developments, you lose a big contract, investor pulls out, even more reason to have a board meeting, talk about it, assess where you are. Very importantly, obviously, is not to start incurring new debt under circumstances where you possibly won't be able to repay it, because now you would be getting into reckless trading territory. You've got to be very careful about how you communicate with creditors, lenders, trade creditors, all of them. So if you admit in writing or verbally that you can't pay your debts, or you start trying to make arrangements to compromise your debt or reschedule debt, it's possible that those sorts of conversations or that sort of correspondence is going to amount to defaults under facilities. Could cause all sorts of cross defaults. It can also be ammunition that's used against you by a creditor who wants to put you into liquidation, for instance. You've got to be very careful of demands you receive from creditors. Some of these could be Section 345 demands, which are demands in a particular format and can be used to liquidate you in due course if you don't respond appropriately to those demands. And we do recommend that to the extent that a company wants to communicate with stakeholders, be those investors, employees, creditors, that you actually have a script that is prepared, people know what they can say, what they can't say, and that script, so to speak, is vetted by your advisors. So turning to the processes that are available, obviously there's liquidation, which I'll get out of the way quickly. That's not a restructuring tool, really. That's where you get to if there's absolutely nothing left. We generally all know how liquidation works. A liquidator comes in and his job is to realize all the assets for as much as possible and then to distribute that money amongst the creditors in their legal order of preference. A company could be put in liquidation either by the company itself by passing a special resolution, or it could be something initiated by a creditor, for instance. The basis on which you put a company on liquidation is liquidity. So that what the court wants to know is that the company is unable to pay its debts as they fall due. So whether you're factually solvent or not, what your assets and liabilities are is not strictly speaking relevant. What is relevant is your liquidity, your ability to pay debts as they fall due. In the event of a liquidation, employees are immediately suspended and their employment terminates 45 days after a final liquidator is appointed. Employees are preferent to some extent in terms of what they get paid before other unsecured creditors, but not in a big way. And then just one last thing on liquidation is one of the duties of a liquidator is then to investigate what went on in the company before its demise. So he will go through its financial records, its bank statements, its contracts. And if he feels that anyone should be held liable for what went on, for example, a director for reckless trading, one of his jobs is to take the appropriate steps. So moving on from liquidation, if we look at business rescue, that's obviously something that's fairly new in South Africa. It came in the new act in 2011, and it sort of hangs off of three pillars. The first is the temporary supervision of the company and the management of its affairs by a business rescue practitioner. So an outside independent person who's appointed to manage the company in substitution for its board. The second pillar is the temporary moratorium on the rights of creditors to take action against the company. So that gives the company some breathing space. No one can take legal action against the company whilst it's in business rescue, except under very limited circumstances, which I won't go into for today's purposes. And then the third thing is the development of a plan to rescue the company. And that plan is supposed to be prepared by the practitioner in consultation with stakeholders, shareholders, employees, creditors, obviously. And there are two things this plan can seek to achieve. So the first is maximizing the likelihood of the company continuing in existence on a solvent basis. So actually rescuing it and putting it out there into the world as a solvent company. If that can't be achieved, one of the aims of the business rescue plan can instead be to result in a better return for the company's creditors and shareholders than would have been the case if it immediately went into liquidation. So this is what we sort of sometimes refer to as a structured wind down. So it's effectively liquidating the company, but it's in a more orderly, slow manner, which ensures that everyone gets a little bit more than they would have got if the axe just fell and you went straight into liquidation. And unfortunately, the reality is that many business rescues these days are that sort of part two, where it's really just a wind down. So a business rescue, again, can be initiated by the company itself or by a creditor, for instance. If the company does it itself, it can do it by resolution. Creditors need to do it by applying to court. And what does the court look at, or what do you have to show? So first of all, the company has to be financially distressed. Now, we've already talked through how that's defined. So it's either that it's going to be unable to pay its debts in the next 6 months, or that it is going to have its liabilities exceeding its assets in the next 6 months. So it's those two. And in addition to showing that the company is financially distressed, you need to show that there's a reasonable prospect of the company being rescued, or in your resolution, you have to swear under oath that you're saying that there's a reasonable prospect of the company being rescued. What happens then? Well, for a start, you've got your general moratorium. So now you effectively have a standstill. Creditors can't take action against the company. One of the quite useful tools in the business rescue practitioner's toolbox is that he can look at contracts the company's entered into, and he can suspend obligations of the company that fall due during business rescue, or even cancel them. If he's going to cancel them, he has to go to court. He can unilaterally suspend, and the counterparty only has a claim for damages. So that's quite a useful tool. If there are prejudicial contracts the company has, you can use this mechanism to go to court and effectively get out of them under appropriate circumstances. And as I said, the counterparty will then just have a damages claim. What happens to directors in business rescue? During business rescue, the directors remain in place, and they must continue to exercise their functions, but they do so under the authority of the practitioner. So the practitioner effectively tells them what he wants them to be doing, and they are answerable to the practitioner. The directors remain bound by the provisions of the Companies Act, so their directors' duties in regard to all personal financial interests, and the business rescue practitioner also picks up all the responsibilities of a director under the Companies Act. The practitioner is also entitled to apply to court to remove directors if they're not cooperating, if they're being obstructive, if they're not providing the information that the practitioner needs from them. The business rescue practitioner, he basically is there in substitution of the board. He can delegate certain tasks to management and often will do so. Obviously, one caveat there is that if the business rescue practitioner feels that anyone has been behaving badly, is perhaps been guilty of misconduct, fraud, etc., he would generally not allow those directors to continue, or members of management to continue fulfilling their previous functions. And that's maybe one point to raise here, is that business rescue is not a great tool to use when you feel like there might have been any fraud, etc., that's gone on in the company, because the business rescue practitioner has got very limited ability to deal with that sort of thing. It may well be that a liquidation is a more appropriate step to take in those cases. Creditors obviously are entitled to participate fully in the business rescue process, and ultimately when a plan is drawn up, they get to vote on this plan. So it's essentially creditors who vote. Shareholders only get to vote to the extent that the plan contemplates an alteration of the rights associated with the class of securities they hold. So if the plan incorporates changing the rights of shareholders, they do have a vote. Otherwise, they don't have a vote at all. It's purely shareholders who vote. And a plan will be approved if it's supported by the holders of more than 75% of the creditors voting. And then also, of those creditors who vote in support, at least 50% of those have to be independent creditors, so they can't be related parties. Just to make it clear also that for creditors is R1, one vote. If I'm owed 100 Rand, I have 100 votes. I'm owed R1, I have one vote. It doesn't matter if you're secured, concurrent, you all vote in the same pool. So it's a mechanism whereby basically 75% of the creditors can get an uncooperative 25% to toe the line and achieve the necessary end. You can really do pretty much anything in a business rescue plan. It can involve a debt to equity conversion. It can involve writing off debt. It can involve selling off the assets, all sorts of things. So it's quite a useful tool and can be effectively used to restructure a company. I'm just going to touch briefly on compromises under the Companies Act. Those are found in section 155 of the Companies Act. It's part of the business rescue chapter, in fact. And this makes provision for a compromise between a company and its creditors, irrespective of whether the company is financially distressed, although it would be quite unusual to see a 155 when you're not in distress. The only people who can propose a compromise are the board of directors, or if the company is in liquidation, a liquidator can propose the 155. So a 155 can be used out of liquidation, and I've seen many of those done where part of the business is taken out of liquidation through a 155. You cannot use a 155 if you're in business rescue, because what the Act contemplates is there you use a business rescue plan to achieve what you want. One of the big downsides of a 155 compromise is that there's no moratorium. So you in danger of creditors being able to take action against the company while you try and put this proposal together. There are ways of dealing with that. You could have some kind of standstill agreed, but it remains one of the disadvantages of a 155. One of the other differences between business rescue and a 155 compromise is when you put together this proposal of what you want to do, creditors vote in classes. So traditionally you would have secured creditors, preferent creditors, concurrent creditors, and your compromise or your proposal could only involve one of those classes. So you might only be trying to, for example, compromise the debt of concurrent creditors and not secured creditors, and that is fairly common. So how it works is a proposal has to be prepared, sent to all the creditors. It sets out exactly what you want to do. And then again, you have meetings and you vote on it. And what you need there is it needs to be supported by a majority of creditors in number, representing 75% in value of each class that votes. And that is another way you can sort of cram down a plan when there are certain dissenting creditors. And it's also something that's sometimes used at the end of a restructure if there are a few holdout creditors who aren't cooperating, and it can be used to sort of get the plan through and cram it down on those who aren't cooperating.
Thanks, Juliette. We've got quite a few questions to get through. I don't know if you...
Okay, well, let's do that. Yeah, I'm happy to stop there.
Okay, great. Mel, do you want to let us know what questions have come through?
Absolutely. So please, if you've got any more questions, put them in the chat box. In the interim, Herbert Meyer, we did see your hand. Put it up again if you still want to ask that question. So Juliette, first question to you. There was a question around, has there ever been a conviction for reckless trading? And then there was a second one is around what exactly is the definition of financial distress? Maybe you can help us with those.
Okay. All right. So to the first question, when you say a conviction, I'm assuming you actually mean a civil, being held liable civilly as opposed to a criminal conviction. I can't really talk to the criminal side, but generally the purpose of trying to hold someone liable is to get money out of them. So you don't want to do it via a criminal action. You want to hold them liable civilly. And yes, there have been many instances of directors being held guilty of reckless trading. I, for my sins, spent a year in court on a case where I was acting for a liquidator trying to hold directors liable. Ultimately, it settled and they paid. Most of these cases either settle just before you get to court or in court, because people would rather not have their dirty laundry aired, and often the directors will pay something to make it go away. But yes, there have been cases where people have been found liable. The second question, the definition of financially distressed, it actually is set out in the Act. It's under section 128 of the Act. And as I said, there's sort of two tests. One is a liquidity test and one is a factual solvency test. And they're both forward-looking. You look to the next 6 months ahead and see whether you can pay your creditors and whether you'll be factually solvent.
Super, thanks for that. And Nicola and Zach, I hope that answers your questions. Moving on to you, Ulrike, there is a question here around whether it would be practicable for the banks to take over the majority of their equity or converted debt to get control, given that it's not really in the normal course of business to run companies, and it can be quite complex and time-consuming to sell these shares. Your views on that?
So, I mean, you're right in the sense that banks are not in the business of holding shares, and banks will not seek to convert their debt to equity in order and with the aim to get control over the company. However, if there's a company that is in distress where the company is potentially factually and technically insolvent due to the amount of debt that the company has on its balance sheet, in order to solve that insolvency issue, a portion of their debt has to be converted into equity, or something has to be done with that debt. So So if shareholders are not prepared to provide further funding, if there's no third-party equity provider that's prepared to invest into the company with the proceeds of that share issuance being used to deleverage the company, in many cases, lenders are forced to convert a portion of the debt into equity. They're more likely to do that where there is very little to no equity value in the business in the first place. Because what lenders are loath to do is hold a minority stake. So they're loath to convert senior secured debt into a small portion of equity that then sits alongside the equity of the existing shareholders. So the other reason why lenders would pursue a debt to equity conversion is ultimately a certain portion of the debt is carrying equity risk. That portion of the debt that needs to be converted to bring the company back to a solvent position is actually carrying equity risk. So lenders will then want to have and hold an equity instrument that allows them to earn the equity return that's due to the risk that they are actually taking.
And I mean, Ulrike, maybe to make the point too, is that the existing management team or a new management team would still do the day-to-day running of the business of the company. And secondly, that as far as I know, a lot of banks have specific workout or stress teams that, you know, it isn't your normal lending team that would be dealing with these kind of situations.
Yeah, I mean, they would be looking to probably hold the equity interest for a period of 12 to 24 months to stabilize the business. And at some point in time, there would be possibly already pre-agreed in the new shareholders agreement with other lenders, some form of agreed exit mechanism pursuant to which the banks sell the business either to a strategic or to trade player or to another private equity house or another form of investor.
This might result in a return to banks having private equity type investments all over again.
Yeah, but just to note, I mean, banks don't like holding debt. It's quite expensive for banks. There are significant holding costs applicable to holding equity. So from a returns perspective, for a bank, it's far more expensive to hold an equity instrument other than a funding preference share versus being a debt provider.
And maybe just to add on to that question then, you know, if you haven't moved to get waivers for events of default yet, like a MAC event, and you're now outside of that window to do so, is there any way that companies can protect themselves now, or is it just now down to a negotiation with the bank?
So in the current circumstances, there are, I mean, just about every facility agreement I've looked at in the last 6 weeks has numerous events of default that have occurred. I think from a legal technical perspective, it's important to note that most facility agreements are drafted in such a manner that an event of default occurs, a default occurs, then there's normally a short remedy period, and then an event of default occurs. Once the event of default has occurred, it remains in place and can be acted on unless the lenders have actually waived that. So even if the company has remedied the actual underlying event, from a legal perspective, the event of default still exists and can still be acted on. Now, that's important for two things. One, or perhaps for three things. One, technically speaking, in most facility agreements, there's default interest that applies to the loan when from the moment that an event of default has occurred. So technically speaking, the banks are entitled to charge additional interest from the moment that the event of default has arisen. Secondly, there are conditions to utilization in most facility agreements where the occurrence or the existence of an event of default is actually a draw stop. So if you're a company and you want to utilize your revolving facility or your general banking facility, in particular in the current environment where you need that kind of liquidity, the bank might not be obliged to fund the utilization request on the basis that there are actually existing events of default. So in order to prudently manage your liquidity, I would suggest that you approach the bank and rather have the event of default waived so that you know that when you do need to draw on your facilities, you can make the representation that there are no events of default occurring or existing at that point in time. And I think thirdly, I don't think it's good for a business or for management to run a company on the basis that there are existing events of default, and lenders may at any point in time exercise their rights under the security instrument. So I think in all cases, I would recommend that the company approaches the lenders and asks for a waiver in my experience, the waivers that have, the events of default that have arisen as a result of the lockdown, the banks have been more than understanding and have really worked closely with the companies to understand the extent of the default and waive those.
Thanks for that, Ulrike. And just a reminder to everybody on the webinar, add your questions to the chat box, and if you're brave enough, put up your hand and we'll have you ask the question directly of the panelist. Tim, I've got a question for you, and it's around whether you can attract liability if you are a shareholder and you use your board representation to request all shareholders to raise funding, knowing that they are unlikely to be able to, and you will increase your shareholding to a majority or a controlling stake.
Thanks, Mel. I mean, I think the important thing to remember here is that the decision to call for funding is a board decision, and the board has to do that in the context of its fiduciary duties, which are to act in the best interest of the company, not the shareholder that appointed that specific director. And secondly, in the context of the process that is set out in the constitutional documents. So, you may well find that is the outcome of a funding call, but it shouldn't be the goal. The goal or the purpose of these funding provisions is to allow the company to raise money from its shareholders, not to enhance the position of one shareholder over another. So you do need to be careful about your motives when you go into these processes. And as I said, from a director's perspective, always keep those fiduciary duties as a front of mind, together with the processes in the constitutional documents. And then I think Josh also touched on it. There are consequences to going across a control threshold. So, from a competition perspective, etc. So I hope that answers the question.
Tim, can I maybe just add on another point there? Right, I think if the company actually needs money, right, and the shareholder is willing to fund, I think it's very unlikely that a director would be found to be breaching his fiduciary duty for putting that forward to the shareholders, even if one shareholder who he potentially represents is the one who takes up the funding call. I think what you also got to remember is Section 75, which deals with conflicts of interest, might prevent him from actually taking part in the vote if it is a matter that only concerns that particular shareholder. But my sense is it would be very unlikely for a director to attract liability in that scenario where the company needs money.
Yeah, I'd agree with that, Josh. I mean, if from a Section 75 perspective, you're all in the same boat, then obviously the exception applies and you can go ahead. But as I said, I think that the outcome may well be like, a dilution, and the outcome that was explained. But I suppose it's the purpose behind why did you go about doing that, and thinking a little bit more about your position, not as a director appointed by a shareholder, but your fiduciary duties.
Yeah, I mean, Josh and Tim, I have seen minority shareholders try to argue some oppression of the minority type stance when it comes to a capital raise that they think has been done specifically to dilute them. But I think you're right. When the company needs the money and their liquidity issues, it's hard to see anybody being prejudiced or being held liable if the consequence of that, the one shareholder who's prepared to risk the money is somehow accused of some oppressive stance. So I think it's very hard to see.
Yeah.
And then there's been an interesting question around incentives, and I think incentives have become really topical over this time. And this question is from Jason regarding management incentives, and particularly restricted equity incentives. Are there some tax considerations that must be taken into account from the perspective of both the company and those who will benefit from the incentives? And how can companies and managers mitigate any tax consequences which may be triggered by providing these restricted or unrestricted equity incentives? Josh, do you want to grab that one?
Sure, thanks, Mel, and thanks, Jason. Look, I think I mean, the short answer is, are there tax considerations? I mean, I think if I know enough about tax, I know that the answer is there's always tax considerations. Let me start this answer by saying I'm not a tax expert, and I think this is a particularly sensitive topic even for tax experts. But yeah, when you're dealing with restricted or unrestricted equity instruments, you always need to take Section 8C of the Income Tax Act into consideration. and what that might mean if you're in the restricted zone, especially when the restrictions lift, and whether there's liquidity to pay any tax that arises at that level. Obviously, bearing in mind that is income tax at the marginal rate, so we're talking 45% potentially. So I think if we're in distressed situations, I think some of the conversations that we've been having at the moment are really looking at these existing restricted equity instruments, so ones that might have kind of adverse tax consequences attaching to them when the restrictions lift. And people are considering lifting the restrictions sooner than they ordinarily would, because the share value is low, and so there's a potential that when you release the restriction and trigger the tax liability, that there's actually a very low tax liability because of the low value of the share. I think that's a very interesting discussion to have. The other thing, and I think this kind of stems from the point I was making earlier on in the presentation, was that in order to keep management incentivized, you need to be thinking of creative ways of keeping them involved. And clearly equity is a way that is going to make sense in a lot of these distress situations. I think because it's so difficult to set proper performance conditions and KPIs, what you're looking at is putting in just a general time-based restriction on an incentive. You know, you allocate a certain percentage of shares to management. They vest in over a period of time, 3 to 5 years, for example. And when they vest, when the restrictions lift, there will be tax. It certainly will be a tax event on that. I mean, there are obviously other ways of working with unrestricted instruments, but you know, whether you're able to manage that properly and keep the team locked in and incentivized is probably a question. And you know, and I suppose what also comes to mind is the time taken to get the recovery. You know, if the value of the unrestricted instruments at the time they're awarded is low, and it takes a while for the company to lift, then you probably need to keep the people involved for a longer period of time as well.
Yeah, maybe if I could just jump in as well. I mean, I think Josh is absolutely right that now may be the right time to lift restrictions on restricted equity instruments. If you are prepared to move away from particularly bad lever restrictions that surround your management team. When it comes to looking at the effect of distress on your management team and on their incentives, I think partly you need to look at the form in which you inject further money into business. So it may be that you would inject shareholder loans into the business rather than diluting management, assuming that you could properly subordinate those shareholder loans. And then you could look at other ways of giving management an incentive program. So, you know, would you do it by way of a fresh equity issue to management? You may not want to do that, simply because, again, there may be dilution of the institutional shareholders. But you may want to look at a range of management incentives that would include bonus payments. The benefit of a bonus payment, of course, is that you do get the tax deduction in the company. So it may be attractive, less attractive to management, of course, because they're paying tax. But it does move in the pecking order from being a shareholder. So I think it's important to think creatively. You can also, you know, particularly in relation to bonuses, you may be looking at more of a sort of short-term incentive where you're relatively easily met. So that may be a cost reduction target. It may be an EBITDA target, but it may be that a bonus is a better sort of short-term incentive to keep management focused than simply giving them more equity in the situation. But I think every business is different, and there are a variety of instruments that one can look now. Is that if you do have management who have restricted equity instruments and have a potential large income, or would have had a potential large income tax liability pre the crisis, and if you are now prepared to lift those restrictions, then there may be a tax benefit in doing so.
Thanks for that, John. And for those who are confused, John sneaked in right at the end. He thought his team was having too much fun. John, of course, heads up the private equity sector for the Bowmans team. Thank you for that contribution, and thank you for joining us, John. I have a question here from Andrew Buchanan, asking whether there's a chance that COVID will cause increased movements toward government-driven debt forgiveness or softening of lender recourse. Now that's a question. I'm looking for a taker. Ulrike, let's unmute you. There we go.
Thank you. I'm happy to take that. So I mean, obviously we're still waiting to see exactly what form of government, what form of financial support government will provide. I don't think government will interfere with the contractual relationship between banks and their large clients. There might be some government-driven initiative or restrictions in relation to smaller, SMEs or even individual bank clients. I don't think that government will interfere in contractual relationships between the banks and the large institutions or companies. I do, however, think that what may well happen is that government, either directly to the banks or through other financial institutions, will make funding available specifically for use to support businesses and service in certain sectors, in particular sectors that have been hardest hit by the crisis. So we've already seen that, for instance, the IDC has made, I think, 150 million Rand available now specifically to businesses that produce PPE equipment. Now that's obviously a very targeted, specific investment, but I think the kind of financial support that businesses are likely to receive are rather in the form of favorable loans. Those can be, I don't think government will extend those loans directly, but will rather provide large funding packages to the banks with a specific mandate on the part of the banks to on-lend those funds to businesses in certain sectors, and probably with a particular mandate to avoid any job losses. So that will probably be a condition of receiving any of those funds.
And I think that's a super important point there, that job preservation, that point around job preservation and doing everything we can. That means every bank as well can to ensure that that happens. A reminder, everybody, if you want to ask a question, drop it into the chat function. As one of my colleagues just remarks, this would have been a very expensive paid for consultation if we were on the paying end of this. So please use this opportunity to ask those questions you would otherwise not be able to afford to ask the Bowmans team while we've got them here. And be brave, put your hand up if you want to ask a question. Ulrike.
Mel, perhaps just an observation that I wanted to share with the audience is I had a conversation with a large investment company based in Germany yesterday, and we were talking about the South African economy and the way that the banks are going about supporting businesses. I'm a finance lawyer. I've been, for the last month, working very closely with either borrower companies or banks to find solutions. And one of the things that has been really important in these discussions is job preservation. So banks have specifically advanced liquidity facilities with a specific mandate on the part of the borrower to use that funding in such a manner that it preserves jobs. And the interesting part of this conversation I had with my counterpart in Germany yesterday was that that doesn't seem to be the case in Germany at all. So banks have not advanced the necessary liquidity and have really held back, placing a lot more reliance. I guess companies in Germany place a lot more reliance on government to step in. In South Africa, I really find it's been business and also the financial services industry that's stepped into the breach. So perhaps just an interesting observation to share with the panelists and the audience.
I mean, I think I can second that, Ulrike. I mean, on some of the restructurings that we've been involved in, I've been amazed at how the banks are actually looking at trying to save companies and enable things to carry on as normal as much as they can. They're not looking just to close positions and liquidate and try and realize some value. They really are dedicated or trying very hard to give companies the time and space that they may need to come out of this.
Yeah, that's why I think it's so important for shareholders, the company itself, and lenders to have that close relationship and a relationship of trust, because I think if they all work together, I think that a very good result can be achieved.
Yes, I think overall amazing leadership being shown throughout private sector, government, and the SMME space. So really, really nice to know that for once South Africa appears to be ahead of the curve. We've got a question here from Kathy Goddard, and true to Kathy's passion, she has a question on gender targets. And if we insist on, the question is really, if we insist on gender targets as a finance condition in the business rescue plan, do you think that that will create complexities or issues? Nobody wants to take that one, Kathy. You've asked the clanger. Let Juliette take it.
I mean, look, are you suggesting that a bank, that a lender, that a financier would put gender targets in place as a condition of a loan? Do you think? Okay, she's saying yes there. Okay, yeah, look, I mean, it comes down to contractual arrangements. So just as a financial institution could say, you know, a loan was conditional on jobs being saved, for instance, you could negotiate that there are certain gender targets that have to be put in place. I don't think there's anything in particular that prevents that from happening. Obviously, it would depend on how viable that is in the context of the company in question. But it's, yeah, it's something. And if a company is desperate for funding and those are the conditions that are imposed, they might be willing to go for it. I think anyone else has got a question on that.
So Kathy, you would have seen Kathy's put it in the chat box there. She's saying less women retrenched than men. Do you think that's the case?
It's all a case of negotiation, I suppose, you know, but you'd have to, it would be a case by case analysis as to whether that kind of conditionality was viable or not.
Perfect. And I think that's been a topical discussion. I think we've seen a focus, Kathy, and you would have been involved in some of these discussions that's been had around really focusing effort around protecting women who are potentially more vulnerable than most and key caregivers in the space, ensuring that they are adequately protected in this scenario and this pandemic that we're facing over an extended period of time. So I think a super important question and a very important focus area as we negotiate COVID-19. I am aware that we are now over time, so I want to do a last call for rounds. Otherwise, if there are no rounds, and Kathy, I'm really sorry you didn't ask your question in person, would have been way more fun. If there are, yes.
There is one question in the Q&A chat box that I can see.
And I see that it's just come. Oh, and I see there's another one from Madula. She's sneaking it in here right at the end. And it's an anonymous attendee who's asking a question in the Q&A box. Anonymous attendee is asking on whether the Bowmans team can share some insight into what they are seeing on the ground in terms of how PE portfolio companies have been impacted by COVID-19 thus far. And I think that's a good question. What are the trends?
I think the one trend perhaps that I can talk to is liquidity. I think with most PE companies that don't operate in the essential services space, having zero revenues over an extended period of time, it's, you know, managing liquidity.
We've certainly seen it in the questions that we've got. It's all about funding.
And I think the other thing is that all of our clients are absolutely engrossed in their portfolios at the moment, you know, and I think for good reason. And perhaps it's premature to see companies sort of being fully in distress yet. I think a number are still kind of managing their way through. But I think whether they are PE portfolio companies or just ordinary companies, I think in the next 6 weeks, we're going to see a lot more distress and a lot more people looking to find ways to salvage their businesses, and lots of opportunity for PE funds, and in particular, potentially mezzanine funds, to get in there and to help to fill that funding gap.
Yes, and
Sorry, Mel, I was going to say, I think John is right. We're seeing a big opportunity for distressed M&A in the next 6 months or so, where, you know, great companies, good management teams just have been caught on the wrong side of this whole corona Corona lockdown disaster, but the underlying basis of the companies are sound. So we certainly are hoping that there will be an uptick in M&A, where funds that have dry powder will be able to grab all these opportunities with both hands.
Absolutely, and we're seeing a lot of interest in the essential services provider space, but not so much in the space outside of that. But I think the lockdown is going to phase out at some point in time, and that's exactly when those opportunities will come to the fore. So get in there early as opposed to waiting for it to happen and being in a queue to get involved in those type of opportunities.
Yeah, I think you're right. Everybody's putting out fires at the moment, but when we get a bit of breathing space and time to think, I really do think there should be some great returns being made in the next cycle on the back of this.
I also think in the space of public to private transactions, I think with the share prices of many good companies being where they are, I think there's a lot of opportunities for takeovers in the public space, listed space.
Yeah. Just to add to that, I mean, currency where it is for international investors, I think that there's a lot of opportunity at the moment. Things are much cheaper than they were 2 months ago. So I think where there are strong companies that have just been affected by the crisis, I think that those are real opportunities.
Yeah, I think that's right. I mean, some of the feedback I'm getting from clients who've actually put offers on the table is that there's still a mindset change that happens to happen in the mind of sellers who're still holding out. But I think that will change as we move forward.
There's an important question in the chat box from Medula. Medula, I'm glad you asked it. We have seen it. As much as we've seen leadership in the space and employers really stepping up, we have also seen some employers step away. And we've heard about employees not being able to get hold of employers' salaries not being paid, salaries not being paid fully. So you've asked the question in the chat box around the likelihood of employees pushing for or applying for liquidation if companies cannot afford to pay or the employer just simply cannot be found. So the UIF benefit that has the special benefit that has been put out there cannot be applied for via the employer. Any view from the panel on the ability
I'm happy to
take that? Thanks, Juliette.
I'm happy to take that. I think, first of all, you've got to remember that if an employee is going to, first of all, an employee is entitled to apply for liquidation and likewise to apply for business rescue. I think in most instances, if an employee is pushed to this point, they're going to be far more inclined to look at a business rescue solution before they look at a liquidation solution, because of course their job is going to come to an end. One of the other differences between liquidation and business rescue is, as I mentioned, in liquidation, your job is automatically suspended and after 45 days terminated. In business rescue, the Labour Relations Act, however, still applies completely. So if a business rescue practitioner wants to get rid of staff, he has to go through the formal processes of the Labour Relations Act and pay full severance packages. So it would be far more beneficial for employees to be caught up in a business rescue. They possibly have a job at the end of it all if the business is saved, and even if it isn't a job for them, they'll still get a proper retrenchment package, which is not the case in a liquidation. So yeah, could happen, but I doubt you'd be pushing for liquidation. It would be business rescue.
Some useful feedback there. Thank you so much for that, Juliette. Medula, I hope that, yes, thank you. It does answer Medula's question. Thanks for that. So I'm aware that we got into the end of our time. I wanted to take an opportunity to thank the panel and specifically John for sneaking in right there at the end. I'm going to give you an opportunity, James, to just close off the panel on behalf of the Bowmans team. But as we say goodbye to you, I just wanted to say thank you to our participants as well for the support that they've shown these webinars and for being so active in engaging with the panel discussions that we had. And as we sign off, I think it's a long weekend coming up, so don't forget that it is. Actually take some time out. James, over to you.
Thanks, Mel. I mean, just to echo your thanks to everybody. I mean, especially to you and Bukiwe and Tanya and the rest of your team behind the doors there, or working from home. I think this is the 9th in the series that you guys have run, and they certainly have all been interesting and informative, and something to keep us busy whilst we're sitting at home. Thanks again to my fellow panelists and to John for jumping in there. And lastly, just to say, I mean, if anybody's got any questions or wants to make any follow-ups, we're always available. It won't immediately result in an invoice, I promise, and we're always happy to see if we can build deep and ongoing relationships with the industry.
Thanks. See you guys next week.
Thank you, everyone.
Thank you.
Thanks.
Thanks, everyone.